IP assets in M&A transactions can be very important. However, they're normally, the IP due diligence portion of it is usually brought up either too late in the process to be effective or not at all, and that can be a big mistake in these types of transactions. So when we're talking about IP assets, what we're really talking about are patents, trademarks, copyright, trade secrets, any agreement that involves technology, website agreements, anything to do with social media. So any kind of agreement relating to that could become very important during an M&A transaction, depending on how critical those assets are to the deal and especially to the deal value. So what we do when we look at IP due diligence is to look at the various assets. Some at the very preliminary level is just to inventory everything that's there and to verify the ownership of that, as well as look at the status of the information so that you know what you're buying is what you expect to buy. And then we can go further and look at other issues related to that, especially in the patent area where we're looking at scope of the patents to see whether the patents in fact cover the products that or services that the company is acquiring, and to make sure that they have freedom to operate, which can actually be more important than having patent protections for that. But some of the things that it doesn't include are looking at the actual value of the IP or some of the other features. Usually you bring in patent valuation consultants to do that. And so that's not typically what we're doing when we do our IP due diligence. Other things that we're not looking at are the financial due diligence. Again, an accountant would normally come in to do those types of things. So why is it important that we do these types of things? And why is it important that the timing is prior to getting to the final negotiations? If the IP assets are critical, we don't want to have a valuation only to be determined to be of no value once the asset has been reviewed. For example, there have been a few big cases where IP due diligence has become particularly critical. One of them related to Rolls-Royce. They were being sold and VW was buying them, and having the trademark was particularly critical. But when they finished the transaction, they realized that VW didn't actually acquire that. It was held by another company, and BMW swooped in and bought the trademark rights to Rolls-Royce, which was in fact the most critical part of the deal. So that's not a very good place to be in. The other one relates to Pine Sol. The Clorox company decided to go in and buy the Pine Sol brand, except they didn't realize that there was an agreement in place that they could have discovered during IP due diligence. And what they did was they bought it believing, and they bought it so that they could expand its use to products beyond pine cleaners, only to find out that based on a litigation settlement, they could only do it for pine cleaners. So they bought something that was essentially of very limited value. So it's always important to do the IP due diligence early in the process.